Welcome to Goodwin Law Unplugged, Florida real estate and more. This podcast features candid insight from real estate industry professionals from all sectors. Your host, attorney Matthew Goodwin, a native Floridian and experienced real estate attorney, will provide his personal insight on legal matters and feature other professionals offering their candid advice. Whether you're a first-time homebuyer, seasoned investor, or experienced real estate agent, there is something for everyone. Thanks for joining us on Goodwin Law Unplugged.
Well, welcome back, everyone. Charlie McDermott here, co-host, producer of the show being Goodwin Law Unplugged. And we've got Matt Goodwin, of course, back in the studio. Matt, how you doing?
I'm doing fantastic. How are you today?
I'm doing great. And once again, awesome episode last time. And you talked about personal property in the last episode. And I just kind of shook my head. And I can't even imagine all you've seen over the years when it comes to personal property and you know, the kind of the interpretation of that and what the buyer thought they were getting and what the seller thought they were bringing with them and all that. So I'm really looking forward to this episode. So I'm going to again turn the mic over to you, Matt. Take it away.
All right. So there's a couple things at play here. One, this is on page 1 of the sales contract, and you'll find this provision in either the Florida Realtor standard as is, or the one here that's more common in Collier County, the Naples area / NABOR contract. And it defines fixtures, and then it defines personal property. The goal of the buyer and the seller is simply to understand and convey with specificity what personal properties included and existing at the effective date, and what, if any, is being excluded that is existing on the effective date. So sometimes there's confusion with what a fixture is. And, something that's attached to the property or built in is really encompassing what a fixture is. And the personal property is where you run into situations where the contract really does its best to cover a lot of things that are generally there. But there's language here that says as applicable, because not all of the items on the default list exist. For instance, personal property, this is from paragraph 1 in the contract. It says, unless excluded in paragraph 1E, which is the next thing we'll talk about, or by other terms of this contract, the following items which are owned by the seller and existing on the property as of the effective date or the initial offer. So that's the key language. Owned by seller and existing. You could probably come up with a situation where maybe the seller had a house guest, or maybe there was something on loan and it wasn't owned by them. If it was not owned, but it was existing, well, it doesn't convey. That's not always clear. If it was existing and or if it was owned and not existing, well, that won't work either. It has to be both. Okay. And but let's talk about some more things. So refrigerator. Now there's an S behind there. So if you have a refrigerator in your garage and in your house and you're taking one with you, make sure you put that as being excluded in the next paragraph. That's where we see a lot of things go wrong. The other really common one, and the contracts were modified in the last couple of years, were TV wall mounts and hardware. Those things leave the biggest holes in walls. Yes. And in some cases, people were tearing them down just because they thought they had to, and they really weren't going to reuse them per se. And it creates all these other issues. So, and there's more to that, but you have window treatments, blinds. You can't take your blinds with you unless you carve out an exception. You can't take your window coverings with you, window treatments, unless you carve out an exception. Same thing, garage door openers. The example we used last time on what happens at closing, you turn over what you have, right? But if you don't have garage door openers, then there's nothing to turn over. What you'll sometimes see is certain items are stricken from the boilerplate terms in the contract because it doesn't exist. That's really not a bad idea. it's not required, but it's a good habit to get into because it really draws attention and helps you become more intimately familiar with. The potential risk in doing that is if you forget to strike something. And there's language in there in the contract that's evident that something is not there. For instance, you read this provision together with the possession provision and occupancy. It talks about garage door openers and keys, but you don't have one. You strike it one place, not the other. You could run into some ambiguity there, right? The key is understand what's there and be specific with inclusions and exclusions.
So how about, have you run into or have heard stories? I'm sure this has got to happen, of people swapping out things. So, I do my whatever, initial, not even a walkthrough before, I purchase a home and it's all agreed, whatever, the washer and dryer is going to be there and it's the latest, greatest model. And then when I do the walkthrough, it's like, one from the 1950s. Does that happen?
It does happen, Charlie. And that, I'm glad you brought that up, because the different forms of the contract cover washer and dryer differently. So in the FAR/BAR as is, or the FAR/BAR contract, it's not mentioned. You have to specifically list it. In the NABOR contract, it's listed in the default terms. And there's a lot of agents that sometimes will use different forms interchangeably depending on what county they're selling property in or buying. And you have to be really aware of what's there so you can make sure and add it. When it comes to changing those things out, though, that does happens in probably more frequently than sometimes caught. So what's more common is things will be accidentally taken as opposed to being swapped out, because swapping something out requires a conscious decision, right?
Yeah.
You're like, hey, maybe they won't notice. or if you had a really nice one and they're more likely to notice, I hope they don't notice, but there's something wrong of what you're doing, right? Yeah. It's a little different when you accidentally take something, which happens a lot. The other things I want to be really clear on, if you don't use the term turnkey furnished in your sales contract unless you have an inventory list that defines what that means, because that is one of the most ambiguous terms or phrases you can use in the sales contract when dealing with personal property. Because if one item is missing and it's not inventory, but it was on there on the effective date and it says turnkey furnished, somebody can raise a stink about that. I've heard a story. That's not a deal I was personally involved in, where there was a very expensive glass fruit bowl that was on the top of a table on a multi-million-dollar transaction, residential property in a ritzy part of Naples, very particular buyer. And the piece wasn't there. And the buyer remembered and asked about it on their walkthrough. And the seller said, well, sorry, we weren't planning on leaving that. And they took it and they refused to give it back. The buyer walked, rightfully so. Wow. And you can imagine how upset everybody must have been. But that may be an extreme example, but it's an example, right? And if you deal in higher end transactions, you want to be really aware of this. Taking a video, being very particular. Look, if you make an offer and it's turnkey furnished and you're not thinking about these things at the time because you're still taking in the whole thing, go back. Take a video, get the inventory, and more importantly, make sure you put anything that's specifically going to be excluded in that particular section, or require the parties to agree on an inventory list within a certain amount of time. But don't leave anything open-ended. So
that's a great idea. Bring a camera.
The other thing is smart home components, security software, right? Security equipment. There's a way to deduce that those things are required to be conveyed, like an iPad that controls the house, for instance. Something smart home components. FAR/BAR doesn't have a specific mention of that, because they figured those can be terms that are added, because most homes don't have that stuff. But in Naples, we see that a lot. And the Naples area / Nabor contract does have a section in their personal property that talks about smart home equipment. So that's why you got to know your contract and make sure your buyers and the sellers do too. And that's all I got for you.
Again, great stuff. For our listeners who are still unsure, even after this series of phenomenal podcasts, there's a lot of ins and outs. Feel free, give Matt and his team a call at 239-207-3403, or get on the website, FL as in Florida, FLEstatelaw.com. And Matt, we'll see you in the next episode.
Thank you, Charlie. See you soon.
Thanks for listening to Goodwin Law Unplugged. To learn more about Goodwin Law and to utilize our services, visit GoodwinEstatelaw.com or call 239-207-3403. Hablamos Espanol. To submit questions or be a guest on a future episode, message us on our website or on social media by searching for Goodwin Law PA in Naples, Florida. This has been Goodwin Law Unplugged. Thanks again for joining us.